Go on the record. We're back on the record in criminal cause D101CR 2023-25 with counsel and Mr. Apodaca present outside the hearing in presence of the jury. What I want to do this morning is spend some time and go over the proposed instructions. I've received two packets. The original packet I received from the state yesterday, and then this morning I was handed a packet of proposed instructions from the defense. Before we start that breakdown, what I want to do is talk to and get some indication from defense counsel. Now that the state is rested and the directed verdict motions have been addressed, if you intend to call witnesses this morning.
Your Honor, this time we don't plan on calling Mr. Apodaca, and the defense will be resting. There are no further witnesses.
Okay, so I need to speak to Mr. Apodaca directly about that process. Go ahead and have a seat, counsel.
Thank you.
Mr. Apodaca, you have the right, sir, this is your trial. You have the right to rely on your presumption of innocence and not take the stand, and there would be an instruction given to the jury that they could not consider that fact for any purpose. You also have the right to take the stand and to testify. You should make that decision after speaking to your attorney and weighing the, the benefits and possible consequences of testifying or not testifying. If you testify, you would be under oath like every other witness, and you would be subject to cross-examination like every other witness. So let me back up and ask you, do you understand that it's your decision ultimately to decide whether or not to testify in your own trial?
I do understand, and I have decided not to testify.
And have you had a chance to discuss the pros and cons, the relative risks and benefits of either testifying or not testifying with your attorneys? Have you had that conversation with your attorneys?
I have.
And would you like additional time to discuss that with your attorneys?
No, Your Honor.
And is it your decision not to testify in this trial?
It is my decision solely.
Okay, have a seat, sir. So we would give instruction 145031 to the jury. Is the defense offering any included offenses of either count number 1 or count number 2?
Yes, Your Honor. Mr. Long and I did agree on quite a few. If you want to go over the ones that we did agree on.
Sure, we can mark those.
Okay.
So working off of the state's precipice, I didn't receive a precipice for the proposed instructions I was given a moment ago.
I put them at the bottom, Your Honor. That's kind of how I do it.
I'm sorry, I didn't hear you.
I put them at the bottom. That's how I do it.
Yeah, no, there's the UJIs on the what we call the dirty package that has those, and then there are clean copies, but there's a precipice somewhere?
I don't have a precipice.
Okay, okay, that's fine. So let's work off of the state's precipice, and then we'll come to those offered by the defense. So the first is requested instruction number 1, which is UJI 14301.
I'm sorry, Your Honor, 14103.
103, I'm sorry.
The defense stipulates.
So it will be given. We'll go back and number these after we've gone through everything.
Okay.
Next is 6001, duty to follow instructions.
Defense stipulates.
Will be given. 5060, presumption of innocence.
Defense stipulates.
Will be given. 6006, sole judges of the facts.
Sorry, defense stipulates.
Will be given. 6008, duty to consult.
Defense stipulates.
Will be given. 6004, multiple counts, single defendant.
Defense stipulates.
Will be given. 6007, jury must not consider penalties.
Defense stipulates.
Will be given. 5020, credibility of witnesses.
Defense stipulates.
Will be given. 5028.
Defense objects.
Okay. So I'll mark it for now. We'll come back to it.
Thank you.
Next is proposed instruction number 10 from the state, 5050, opinion testimony.
Defense stipulates.
Will be given. Next is 14118, expert witness testimony.
Defense stipulates.
Will be given. Then, as I just said, 5031 will be given, which is defendant not testifying. Then we go to elements instructions for count number 1, 14201
Defense stipulates.
will be given. Then we have the 2822, the aiding and abetting statute, instruction
Defense stipulates.
will be given. Then we have going to elements instruction for count number 2, 14210.
Okay, I think Mr. Long and I did agree on this, but I still have it marked as a, did you fix that one?
So,
Mr. Long?
Judge, what I did was, because they're not going to be asking for a step down to voluntary manslaughter, then Mr. Cameron was like, hey, Tony, I think it's 211. As a matter of fact, it actually is 211, since they're not asking for that step down. So I just replaced 210 with 211.
And is that what I have in this packet?
That is not what you have in this packet, but it is what we have agreed on.
Okay, so I'm gonna, so you're stipulating to 14211, which we're going to collate into the packet.
Yes, sir.
Okay. So I've marked it on the precipice as, will be given as 211 as the replacement. So then we go to, those are, the defense is not offering any other level of homicide as to count 1, is that correct?
We are requesting a step down to count 2.
Okay, I'm talking about count 1.
Oh,
Let's
yeah.
finish count 1.
I mean, I'm sorry, requesting a step down to second-degree murder on count 1.
Okay.
The state's proposing the same.
So we should have, since we're talking about count 1, we should have A and B,
We do, Your Honor.
which is 14602A and 6002B. So is there any objection to those being given as proffered?
So 6002A, there's no objection. 6002B, the defense does has an objection, and we'll discuss that with our version of the step down on count 2.
6002B is the second half of count 1.
Yes, sir.
Okay, we'll come back to it. I've marked it here. Then we have elements instruction 142810, and that's being replaced with 142811. Is that correct?
No, sir. We were requesting 14210 to be replaced with 14211. So 142810, we do stipulate.
Okay. Then we have under that the general intent instruction 14141.
And the defense does object to that.
Okay, so we'll mark it and have that conversation. Then we have 14222, sufficient provocation.
The defense withdraws.
I'm sorry.
The defense withdraws that.
That we're talking about what the state is offering.
Yes, sir. Well,
So you're withdrawing,
so withdrawing, well, we're okay with withdrawing it because we're not going to do a sufficient provocation with regard to manslaughter.
okay. Mr. Long?
So since we've taken out 210, which requires sufficient provocation, and we're substituting that for 211, which does not require sufficient provocation, then we've agreed to that withdrawal.
Okay. So that is withdrawn by